Mr. Charles will walk us through some other changes.
Great, thank you, Senator Sears, and good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel. As Senator Sears said, here to walk the committee through a portion of S58, two portions actually. There's some different subjects being covered in the bill now, and the first two that I'm going to talk to the committee about were originally in S207, I believe. And they relate to, the first piece will relate to the Big 12 offenses, the second piece will relate to the Raise the Age initiative. On the first topic, which is Big 12 juvenile offenses, I'm sure the committee remembers that the concept of the Big 12 is that it distinguishes which crimes, when they're committed by someone 18 years of age or younger, are either commenced either in the family division as a juvenile case or in the criminal division as an adult criminal matter. Whether or not the case starts in the family division or the criminal division depends not only on how old the person is, in this case it's 18 and younger, but it also depends on what type of offense it is. Right now in current law, you have this Big 12, what's referred to as Big 12, those offenses begin in the criminal division. So if it's committed by someone 18 years of age or younger, it starts in criminal division. And now there is always an option, though. Remember that if the state's attorney chooses, rather than starting it in the criminal division, it can start in the family division as a youthful offender proceeding. So not as a juvenile proceeding, but as a youthful offender proceeding. So those are the two options at the outset, but it has to go in one place or the other. Generally speaking, though, unless it starts as a youthful offender type of proceeding, then it must begin in the criminal division if it's one of the Big 12. So the proposal that you have in front of you is to change that Big 12 in two different ways, to essentially strike one offense from the existing Big 12 and add three new ones. So that's the proposal. You'll see over on page 2, starts in the underlying language on line 12. These are the three new offenses that are proposed to be added to the Big 12. Now, one key point here, if you look at page 2, line 13, you'll see these only apply if the criminal act is committed when the person is age 16 or older. Now that's important because usually the line is 14 years of age or older. So for ordinary Big 12 offenses, a person 14 years of age or older who commits it starts in the criminal division. So this isn't quite as broad as your typical Big 12 offense. It's a little bit narrower because it doesn't apply to 14 and 15-year-olds. Only applies starting at age 16. So if you're age 16 or older, but have not turned 22 yet, so age 16 to 21, and you commit one of these three newly listed offenses, then it would start in the criminal division. And what are the three listed offenses? You see them bottom of page 2, over on the top of page 3, using a firearm while committing a felony, drug trafficking, and aggravated stalking. So those are the three. And remember that it's also using a firearm, not just possessing a firearm. So one has to actually have used it in the commission of the offense, not simply carried it or possessed it. So the proposal is add those three, and as I mentioned, strike one, take one away. And that is over on the top of page 4, burglary into an occupied dwelling. That's a current Big 12 offense. Proposal is to make that not a Big 12 offense any longer. So that means burglary into an occupied dwelling will be treated as the vast majority of other offenses are, which is if it's committed by someone this age, it would now start in the family division, not the criminal division. So it would be a juvenile case, not an adult criminal case.
But it could go up.
Yes, can always be transferred up after a hearing. Yeah. So that's the Big 12 piece. Moving on to the Raise the Age piece, you see that begins on page 4. And you may recall, I'm sure by now, that the Raise the Age initiative is something that Vermont has been doing for the last several years to increase the maximum age at which someone can be treated as a juvenile in the family division instead of treated as an adult in the criminal division. Up until 2020, that maximum age was 17. When Raise the Age took effect for the first time, the first step of it took effect in 2020, that raise bumped up to age 18. So now, age 18 and younger children who commit one of those non-Big 12 offenses, their cases will start in the family division. It used to be if you were 18 up until 2020, your case would start in the criminal division. So that was step 1 of Raise the Age. Step 2 is to bump it up another year to age 19 So age 19 and younger youth who commit one of the non-Big 12 offenses would start in the family division. But that second step, to have that raise the age, extend to 19-year-olds. So the 19-year-olds would go to the family division if they committed a non-Big 12 offense. It was originally supposed to take effect in 2022. The legislature bumped that out a year post-COVID. It was going to take effect in 2023. And the legislature bumped that out one more year to this summer, July 1st, 2024. And that's when it's currently scheduled to go into effect. The proposal that you see in front of you is to bump it out, not a full additional year, but about 9 more months to April 1st, 2024, I believe. I'm just going to double check.
Yeah.
Or 2025, sorry. April 1st, 2025, right. And that's actually in the effective date of the amendment on the very last page of the bill, page 13. So that that last phase of the Raise the Age initiative to include 19-year-olds in the family division when they commit a non-Big 12 offense would go into effect next spring, April 1st, 2025. And in conjunction with that, and that's all done technically as a technical matter between pages 5 to 7. But over on page 7, you'll see an additional piece the committee talked about, which is these monthly progress reports to justice oversight. So the requirement is that DCF every other month now, the Department for Children and Families is required to provide justice oversight as well as the committees of jurisdiction with these benchmark reports that are supposed to describe the steps that they've taken to implement several goals related to Raise the Age. And those goals are listed. There are 11 of them starting on page 8 over onto page 9. Rather than go through all those, the committee's gone through those pretty carefully, but one additional provision that was discussed and has now been added over on page 9, lines 5 to 7, I think the committee wanted to make sure that there wasn't sort of an implication that if the department felt they had failed to meet one of those goals, that would serve as a grounds for not implementing Raise the Age. So that's what the language on page 9 is intended to do.
And I like that. I appreciate that.
Oh, great. Thank you. Yep. So expressly puts down that failure to meet one or more of those elements is not a basis for extending the implementation of Raise the Age beyond April 1st.
That it would take, if this bill passed in its present form, it would take legislative action to move beyond April 1st. Am I correct?
Exactly. Correct.
So
You did nothing.
The administration can't say, well, we're not going to do it. We don't feel we can do it, and so we're just not going to do it. They wouldn't have a choice.
That would not be permitted by the language.
Unless the legislature, say the Budget Adjustment Act, was to provide more time.
Right.
So as long as it takes legislative action to undo the April 1st amendment, I think that provides us with it.
Yes, it would take legislative action, definitely.
Okay. Any other questions about Eric's sections? I think Eric, great job.
Thank you.
As always, we appreciate it.
Yep.
And stay tuned.
Yes. Hopefully.
So Michelle is the drug crimes.
I was waiting to see where that was going.
It's
Drug crimes person. Not,
I just always think of you as the cannabis person.
well, I just want to mention something, Michelle. It's so helpful. Senator Ron Hinsdale had a constituent concern about a particular charges against someone and felt that, a 3-year statute of limitations wasn't enough, and should we consider expanding it? It had to do with child porn. And so I responded to Senator Rand Hinsdale with just a copy to Michelle. who immediately, answered the concern was, not knowing the details of the case, why they didn't charge with a crime that has a 40-year statute of limitations, not a 3-year. And the offense had happened 7 years before. It was really helpful. And I'm always wondering whether state attorneys and others who make these charging decisions are aware of other laws. Because what they basically did was closed off any avenue to prosecute this case because of the statute of limitations, but we've already developed. I thought it was 30 years, but it was turned to be 40.
Yeah, y'all had changed that a little while back.
So it's sometimes these, it makes me wonder how do we get this information out to. They think we need to change the law when they've already changed it. That was very helpful.
Good, I'm glad.
So I wanted to mention that before we started on this.
Always happy to help.
It leaves us scratching our heads though on why they do these, because this isn't the first time this has happened. Where they say, oh, we need to change the law.
If I can ever cut off a potential draft request with a short email, I'm up for it.
Yeah.
So I'm gonna take you through the second half, and should sound pretty familiar at this point. So looking at draft 7.1 starts on page 9. So there's some reader assist in there for drug crimes. So section 11, this is amending the definition section for chapter 84 and title 18, which is your regulated drug chapter. So you've done a few things here. You'll see in subdivision 29 to the list of regulated drugs, you've added xylazine because that is currently not a regulated drug, as you'll recall. You've also on page 10, you've added a new definition of fentanyl because you have that specific fentanyl crime for dispensing and sale in chapter 84. You also add a new definition of knowingly for the purposes of all of chapter 84. You recall that the way that the crimes are structured in chapter 84 is that it will always say a person who either possesses, dispenses, or sells knowingly and unlawfully. And so you have that mens rea that is applied to those drug crimes. And so this is the new definition of knowingly. You also have a definition of xylazine, since we're adding that to the list of regulated drugs.
Michelle, general question about this. I asked another witness this question and wanted to run it by you, but if these changes were to be made and somebody was arrested, charged with possession of heroin, would they also be able to be charged with possession of a regulated drug?
Under like another provision, like rather than the heroin statute?
No, I mean, if this were to pass, would a person theoretically be able to be charged with possession of heroin and also possession of a regulated drug?
I don't believe so. So we have a specific heroin statute, as you know, and so the specific's going to control. We do have a general statute for kind of unidentified narcotic stimulants and depressants, which is 4234, and that's that statute that says, so that's like to catch all the things that aren't specifically named as regulated drugs. Here, so you have, if you look at the list of regulated drugs, it talks about like a narcotic drug, but if you, let's say something like OxyContin, right, is a narcotic, but it's not specific, it doesn't have its own specific statute the way that heroin or cocaine or something like that is, and so it would fall under that definition of narcotic and would be prosecuted under 4234, but I would imagine that it doesn't make any sense to me that you would prosecute under 4234 and the heroin statute, because you're charging under both, but
sorry, actually, I think my fault. I think I left out an important fact, which is, so let's say, a person is in possession of heroin baggies, and there's also the presumption that all heroin baggies contain fentanyl. And so if they're in possession of both the heroin and the fentanyl in one bag, would that be two simultaneous.
Right, well, I would say, and this is, just in my layperson's looking at the way the statutes are, and I don't know the way that prosecutors' offices are approaching this, but the way that you have the definitions and the way that the drug statutes are organized is that if it talks about like a combination or I'd have to look at the language, but it's a mixture of substances that contains heroin, that contains fentanyl, things like that. So it doesn't have to, we had this discussion earlier that if you had an ounce of powdered something, right? And there could be all kinds of things in there. And I believe that Ms. Conti testified from the lab that if they test for the presence of things, but they're not necessarily saying, well, there was this much fentanyl, there was this much heroin, there was this much baking soda or whatever. But they go by the aggregate amount. And so, this is just, I hadn't really thought about this before, and I need to, do a little more research, but I don't see how the statute would necessarily preclude you from charging under both. But that's something I think that you'd want to hear from the practitioners from the state's attorneys and the Defender General's office about whether or not they see that as a common practice. I hadn't heard of people doing that. So if you're talking about like the same amount, like it's the same thing, can you prosecute for two different drugs under two different statutes? Is what you're asking, right?
Essentially, and it's coming from from what I'm reading regarding this assumption or the inference that all heroin bags also contain fentanyl, and if you're in possession of fentanyl, it's a violation of possession of a regulated drug. And if you're in possession of heroin, it's... Right.
I'd want to take a look at the case law and see if that issue's ever been addressed by the courts. If there, is a prosecution, basically for the same act with the same substance, can you prosecute under both? I don't know necessarily off the top of my head, but I don't see how the language itself precludes it, because if it's containing both.
Yeah. But doesn't the language say, and this was what I found a little strange, it says that if it contains any fentanyl, then it's all fentanyl. Wasn't that the original language?
The original,
I don't know if it's still in there, but
I thought it was a presumption that all heroin bags contain fentanyl, because it's so...
So my understanding of the testimony that we heard is because they go by the aggregate weight, they could charge for any substance in there at that aggregate weight level.
yes, but
So if it's an ounce of mixed substance that contains fentanyl, they could charge for an ounce of fentanyl.
correct.
right. But I'm thinking that precludes what Senator Hashim is talking about, which is charging that it's both things at once.
Right.
Yeah.
Right. No, I get your point. Yeah. I don't know. It's an excellent question. I can certainly take a look at that and talk to some folks.
Do that,
Sure.
but moving along, I don't, limited time.
Sure.
So maybe we can answer
I'll
that
take a look. I'll look at the case law and I'll reach out to
before,
folks. But
before we
thanks for
do a
bringing
final
that up.
vote on the bill.
Okay.
But the goal here was to make the knowingly what is, if you're selling heroin, you have to recognize there's probably fentanyl in it. If you're selling cocaine, you have to recognize there's probably xylazine in it. That's how my understanding, 50% chance there's xylazine in it. I have no idea why they're adding the xylazine to cocaine, but it seems like that's more common. Senator Sheen.
And another question for you, Michelle, regarding the knowingly standard is, so consciously ignoring, we've had conversations about it being quite similar to the recklessness standard. Is this standard of knowingly, this consciously ignoring a substantial risk, does that exist anywhere else under the knowingly standard for other crimes?
We can take a look.
Thank you.
I know that, I'm trying to think. I'll take a look.
Thank you. That's
So, bottom of page 10, section 12, this is your new statute on xylazine. Senator Viahoski asked me before, because I did have in the earlier drafts, I did have possess in here, although there was no penalty for that, but I was trying to kind of set the stage for the accepted uses, which is what the language that we got from the from the veterinarians and looking at the federal legislation. I think it's fine if you just take it out, which is what I did, so that there's not any confusion. There was never any penalty for possession or anything like that. It was just that you're not to possess, dispense, or sell. But now this is just, you shall not dispense or sell, and then I left B the same with regard to xylazine for the approved uses with animals. Section 13, which is the bottom of page 11, and this is the section on selling or dispensing a regulated drug with death resulting.
Can I ask the difference between a permissive inference and a rebuttable presumption?
Yeah, but permissive inference is something that the jury may take into consideration and weigh. So if you say, you may consider that if A, then B, but they are not required to accept that.
I see.
But there is a permit, but they are permitted to assume that. So kind of the idea of, if there is this baggie being marketed as yours, you know, a baggie of cocaine, I mean, or whatever it is, that you may infer that, you know, that it has fentanyl in it, and that the person, you know, was aware that it had fentanyl in it because of the common knowledge that fentanyl is in all of it. But
okay, and then a rebuttable presumption is not permissive because you have to rebut it.
Exactly.
Yeah, okay.
Yeah.
Great.
Yeah, so there's more leeway there for the jury to be able to decide for themselves.
I like to know the terms of art.
Yeah, no, it's great. And so, page 13, section
Before you
14.
go there, on
Sure.
page 12,
Uh-huh.
current law is a 2-year to 20-year sentence, correct?
Correct.
And
that's not
under
changed.
current law, you didn't have the ability for the court to make it lesser than 2 years. And this puts in, or is this part of current law? Down at the bottom on line
subsection
17
C?
20. It's underlined, so I'm assuming it's new law.
It is new. So right now, there is a mandatory minimum of 20 years.
This allows the court to not do the mandatory minimum. I'm thinking back to the testimony that I get into the argument with Jay Green about, which testimony was, well, many times family members who give the drug to the other, and the family member doesn't want to see their other family member go to jail. And I argue, well, you know, in a case where they throw the guy out of the motel because he's dying from an overdose, and then tell the person to drive him around the block so they don't die in the parking lot, I don't want them treated the same as that. So that's where I get into the argument. That really does focus on the issue regarding a family member, for example, right? Am I reading that?
Well, I think you're talking about C2, about the court doesn't have to impose the
If
sentence.
it's in the interest of justice.
Right. However, you have to read that in concert with C1, because right now, if you look at the language in subsection A, and you see it's a 2-year mandatory minimum and with 20 years. But as you guys well know, it could be that they don't necessarily have to do a term of imprisonment. They can do they have a variety of options there.
Okay.
And so what you have in subsection C, and you've used this elsewhere in statute, like in the aggravated sexual assault statute, some of the sex crimes, where you have said that a certain amount of the sentence has to be served. It can't be deferred. It can't be done on a probationary sentence or things like that. And so you'll see in subdivision C1, this is requiring that 2-year mandatory minimum has to be served and can't be suspended, deferred, or served in the community sentence. But then C2 says, we're going to make you serve it. However, there is kind of an exit for that, which is subdivision 2 saying that the court may impose a sentence that does not include the mandatory serving of the 2 years if the court makes written findings on the record that the sentence will serve the interests of justice. Okay.
Thank you. Now, section 14.
Section 14, this is your flash citation for, so if a person is arrested or cited for dispensing or selling a regulated drug, they are to be arraigned the next business day. If the alleged illegal activity occurred at a dwelling where the person is not a legal tenant. And then subsection B is that unless the person is held without bail for a violent offense, under which they're permitted to be held without bail, the state's attorney shall request conditions of release for that person. And the court can include as a condition of release that the person is prohibited from returning to that location where they were found to be dispensing or selling and not to be a legal tenant in that location.
The committee will note that the sections dealing with the actual renter or leaseholder have been removed. That was after the Economic Development, Housing and General Affairs Committee looked at that portion of the bill, and their recommendation was to continue to look at how to deal with tenants who are involved in illegal activity, but there's already the law for 14 days and they recommended taking it out. So that's, this draft takes those sections out at the recommendation of that committee.
Did they say why it's not just
They felt it was the same testimony we got from the advocates for the housing. Evidently they got from that Vermont Legal Aid attorney. And evidently, so we can put it in, but I asked Michelle to take it out for the purposes of this draft because I didn't want the battle between two committees on the floor.
Much appreciated.
Pardon me?
Much appreciated.
Well, that plus the fact that we can deal with it in another bill if we can come up with some language that at least we should continue to look at it. But there is the 14 days in statute. And it's like what I was talking about earlier with Michelle, for whatever about the statute of limitations, for whatever reason, we're not using that 14 days when there's criminal activity.
I think there's also an expedited process for agricultural individuals as far as the eviction process is concerned. And back in the previous profession, when the House and the Senate passed that bill, my first thought was, well, why don't you just make that applicable to all individuals? But for whatever reason, they were just looking out for our agricultural specialists at that time.
Yeah.
So there is another exception within the rules as far as the time frame is concerned.
Any other questions or comments?
I do just want to note on page 12, and I think I understand this, Michelle, but I'll just ask it anyway. So C1, line 12, seems to say that there can't be anything other than this particular sentence, but then the exception is the paragraph below, which says as long as they create written findings, they can essentially ignore the previous paragraph.
Correct.
Okay. Because I don't like the previous paragraph, and I wouldn't vote for that, but it just seems like a long way of saying, the judge can use judicial interpretation, just has to back it up with a written finding.
Correct. I was going to look and see. So again, this is part of what was originally proposed by the administration in there. So I'm not sure, I'm just gonna look really quickly at our sexual assault statute, because this is like, I know in the sex crimes is where we do have the, language around, having to serve, I don't think we have something like that in there, but
I remember that in other
right,
statutes.
Yeah,
right. I'll take a look and see if we,
but I do think it answers one of the criticisms of the bill. Where the idea that if two brothers, one brother gives the drug to the other or sells it to the other,
Yeah.
the brother dies and, you know, or the circumstance doesn't necessarily mean.
oh, we do actually have it in there,
And
in the other sections. in
And
the
I
section.
thought we were going to put something about, having the Department of Health re-advertise the Good Samaritan law.
Oh, right, that did come up, okay, I will add that,
I don't know any other good way to put that.
okay,
I don't think it should be written that way, but it was, get the word out again, there is, Vermont does have a Good Samaritan law, it's been in effect for years, and
right.
Hard thing to advertise.
well, I know, but it's,
You know.
but, you know, we're advertising Narcan, we're advertising
Yeah.
all kinds of other stuff. And I would think we could put in, you know, that Vermont law does provide.
Yeah. No, I get it, it's just, I wouldn't want to be the ad executive charged with coming up with that language.
Maybe it's less of an ad and more of a PSA,
Yeah,
public service
Yeah, that
announcement.
would have been a better thing to say, PSA, but I just think it's kind of ironic that they advise you to take a drug with somebody else.
yeah,
Don't use alone. Then they don't tell you that if you are the somebody else, you can report the overdose and not be complicit.
I'll reach out to our healthcare attorneys and see whether or not they know of a certain program that the
I
health
think it's
department
like
does
a
or
lot of
something
things,
that-
we put things into practice, they work, and then we forget them and we go on to newer and better things and forget the old things that do work and are still on the books.
And so I just wanted to reiterate is that, so for aggravated sexual assault, you have a 10-year minimum with a life maximum. Although, the, 10-year, and it says, specifies the 10-year minimum is to be served, not suspended.
and then
However,
has the same.
the court may depart downly from the 10-year term, and impose a lesser term of incarceration if the court makes written findings on the record that the downward departure will serve the interests of justice and public safety, provided that in no event may the court impose the term of incarceration of less than 5 years. And so this is saying in subdivision 2 that you actually don't have to require serving at all, but you have to make the findings. So there's a parallel right now in some of our sex offense statutes.
Okay, so can we have, do you have Friday morning at 9
Sure.
to vote on? I don't think it'll take long to have a vote. What do you think, Ben? Can we do it at 9?
Yes, 9 is wide open. I have,
So I'm not available at 9. I mean, I don't know if y'all would need me,
What's
but
that?
I'm not available at 9. I'm somewhere else, but I
Well,
am.
then, just tell them you can't go with us,
Okay.
especially if it's the house.
It's not.
Oh,
so you're available at 10:30.
I am. I'm available after 9:45.
I can switch 285 to 9 and do 285.
if Ben is available.
Ben is available all day.
Okay, well, Ben, put her in at 9:45.
9:45? Do we need more time for 285 or do you think 45 minutes should be okay?
I think we're pretty close on all three. Senator Bowles.
Yeah, before we close our hearing today, I received a letter, and I think other members of the committee did as well, from the chair of the Vermont Overdose Prevention Network, and I was asked to read it, so I would like to do that. And it says, "Dear Senate Judiciary Committee, thank you so much for all of your efforts to reduce overdose deaths in Vermont. One of the most challenging elements of drug policy is the unintended consequences are difficult to see and are often more severe and dangerous than the conditions that they strive to remedy. Data shows that with S58, it would be counterproductive and harmful as we will lose more lives, reduce or eliminate calls to 911, and more than half of the time ensnare and prosecute the most vulnerable people in the overdose epidemic. A national analysis of delivery with death resulting and similar laws indicate that the majority of individuals accused of delivery with death resulting and similar crimes are not dealers, but instead friends, families, spouses, and partners of the deceased. The vast majority of those people also have substance use disorder, and in many cases, they have pooled their money, shared or sold small amounts of drugs to fund their own addiction. With the pooling of resources, the role of a supplier also changes from day to day, and sadly, so does the potential of being a victim of an overdose. Data also demonstrates that delivery with death resulting laws do not deter drug dealing, but instead undermine life-saving evidence-based efforts. According to the U.S. Department of Justice, sending an individual convicted of a crime to prison is not a very effective way to deter crime, and prison sentences, particularly long sentences, are unlikely to deter future crime. More severe punishments do not chasten individuals convicted of crimes, and prisons may exacerbate recidivism. According to a Pew report, not only do sentence lengths not deter crime, incarceration itself shows to have no impact on drug use or overdose rates. These laws can further compound tragedy as people exiting incarceration are 129% greater risk of dying from overdose than the general public. One of the unintended consequences of S58 has the potential to undo all of our hard work on the Good Samaritan law. The threat of arrest and prosecution will reduce or eliminate calls to 911. With our goal to reduce overdose deaths, the bystanders are our greatest assets, and people on the scene are oftentimes the overdose victim's only chance for life-saving measures like the administration of naloxone, providing rescue breathing, and calling 911. Our laws should work to increase the chances that bystanders are protected to stay, render aid, and call for help. Sadly, Good Sam has not worked as intended, and we know that by adding consequences would virtually eliminate people calling for help. The way to remedy this would be to strengthen Good Sam's protections and work to educate the public on the law, especially in these potential worst-case scenarios that the bill is striving to address. More protection for the people on the scene is the only chance we have to create an environment where they can feel safe calling for help. The people on the scene are the first responders, and the more protection they have, the choice to call for help becomes more likely and automatic. Additionally, evidence from the US and Canada shows that strong social ties between drug suppliers and users are potentially protective from overdose, and that prosecution and incarceration of suppliers would potentially increase opioid overdose deaths. We should focus our resources on evidence-based life-saving strategies. With the cost of incarcerating an individual in Vermont close to $100,000, S58 is expensive and counterproductive. As someone who's worked in harm reduction for 15 years, $100,000 for life-saving evidence-based practices is hard to secure. Our communities desperately need housing, harm reduction, and methadone and Suboxone access, all of which are proven to reduce overdoses. When the stakes are life and death, we should invest our limited resources in data-driven responses that keep people alive and capitalize on the protective networks that exist in our community. Thank you so much for your time and dedication to reducing overdoses in Vermont. We are forever grateful. Sincerely, Grace Keller, Chair of the Vermont Overdose Prevention Network. So thank you for letting me read that into the record as I was asked.
I disagree.
Mr. Chair.
No,
Go ahead.
let me say, first of all, we have a crisis, I admit that, and we're trying to deal with it in a rational way. The knowingly standard avoids prosecuting some people, current knowingly, when death results from an overdose. Those people who are callous, who disregard completely for life, deserve to be incarcerated. And if we're going to be a state that looks at harm reduction, et cetera, which I'm glad we are, I'm glad we give the latitude to our prosecutors. And this bill gives the latitude to the courts to determine whether or not somebody should serve any jail time at all, let alone under current law, it's 2 to 20 years. We could have left that alone, and we didn't. We put in some language so it allows that discretion. We have putting in language regarding the Good Samaritan law. I think we have a balanced bill here that looks at some of the crises our communities are facing and tries to deal with. It goes along with harm reduction strategies and other strategies that other committees are working on. Our job is to look at some of the criminal aspects, particularly the xylazine and the use of fentanyl, which is growing. S58 does that. And so I just kind of disagree with Grace on this one. I've agreed with Grace many times, and I don't mind criticism at all. But I think they're not looking at the whole picture. And it's time to hold people accountable who commit these crimes with callous disregard for the life of somebody else. And to be honest with you, somebody trying to say, well, I didn't know there was fentanyl in there, that's BS. Senator? Sorry for that little.
No. I think it's a good colloquy, back and forth. I would say, my way of looking at it is we already have this offense, right, Michelle? This is existing law that we have this crime.
For,
Death
result,
resulting.
correct?
And the language currently in law is not less than 2 years, period. So what we're adding, in addition to removing a defense somebody might have, is discretion for the judge. So we're not creating the crime, we're giving more discretion for the judge in assigning a penalty. The only way you could say we're tightening it is we're getting rid of a common defense that people use, which is that there were multiple drugs in the bag.
Yeah.
So I don't view it as we're creating the crime of death resulting. We're actually making that less likely to be a full sentence served for that crime.
Well, I don't think the concern is that we're creating the new crime. It's that the data, the 50 or so years of data show that increased sentencing doesn't.
But she's arguing for striking from current law that crime, I think.
That's not how I read it.
Well, I don't know, because what we're doing isn't creating that crime or making the penalty more severe. So I think the only way to read what she's saying is we should eliminate that crime.
And I also caution people about using the $94,000 term for incarceration. That presumes that you could eliminate 20 beds, for example, and save that kind of money. But it still costs the same to run a facility, whether you have 20 beds less or not. The only savings are from out-of-state beds. And that's, I believe she said 36,000 today.
Mm-hmm.
So the only way you save money in Green, until we get everybody out of the out-of-state beds, is the 36,000 a year. Because you're gonna take people out of state for an
And the way I read it is that by putting more people in prison,
I
we're
know,
going to spend more money.
But they've been doing this for 100 years. Back when it was 50,000 a bed, they were arguing, we need the 50,000 for this or that or the other thing, rather than spending it on, and I'm mainly pointing out that the actual number is 36,000. Because until you actually reduce like hundreds of people and close a prison like they're doing in New York State, you don't have savings.
Well, that was gonna be my next point, is if we did
Well,
policy
yeah,
to decarcerate more people in closed facilities,